All right, this is 19-0511, the People versus Bobby Joe Thomas.
Good afternoon, Your Honor. Jeffrey Phantom on behalf of Ms. Thomas. Wait formal reading request warrant B.
Okay, so I'll enter a not guilty plea on your client's behalf. Right, ma'am, you're here for arraignment. I've entered you a not guilty plea on your behalf.
Okay.
And I've signed the request for a court-appointed attorney. I see that she'd previously been arraigned on this charge. She's failed to, it looks like, on more than one occasion. She showed. This is a misdemeanor case. Ma'am, you have the right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law, okay?
Okay.
Did you go over these constitutional rights with your attorney?
Yes.
Did you understand these rights?
Yes.
And did you give your attorney permission to sign your name on this advice of rights form?
Yes.
Okay, so we'll give her a pre-trial date. It looks like Mr. Fanto, with respect to bond.
Judge, this is a 2019 case. She has no new charges since then. Having some significant financial issues, and she also has significant medical issues. So I would request a personal bond.
Well, she was arraigned on this case in February of 19. She had a warrant in March of 19. Then she was arraigned again in November of 19, was given another bond, failed to appear again at court. And then on July 5th, she was picked up again and given another personal bond. And again, I mean, it's a misdemeanor offense, but the reason it's so old is because she never comes to court. So I gave her a personal bond on July 5th, and I'm positive on that date she promised me she was going to come to court, and she didn't. And now another year and some has gone by. She failed to appear for court. She was back in warrant status, and a year later, so I mean, this case is going to get super, super old if she gets a personal bond because she doesn't come to court. So I'll make sure she comes.
You're in big trouble, lady.
She has a $2,500 cash bond.
Oh my God.
They won't let me out, no. They won't let me out.
Ma'am, that you don't come to court. You've left me no choice. You're to appear in court as directed. You're not to leave the state without permission of the court.
Stay out of Fulton County, sir. The only reason you're going to come to Fulton County is court or to see your lawyer. Not even get gas. Can't even stop at Chick-fil-A.
You're immediately to notify the court of change of address or phone number. You're not to commit any crimes while released. You're not to purchase or consume alcohol or drugs, and you can't drive without a valid license. And I'm going to write on here to set your pretrial as soon as possible.
Judge, you could mark the file medical, and I'll approach with the reasons.
All right. I'll make sure the file's marked medical.
Thank you.
All right, ma'am. You're all set. Thank you.
All right.
Hand me my spitting box. It's number 32.
Number 32, People versus Tygar Moore, 22144 SH.
How's Oakland County playing in the sandbox today?
Here we have another.
Oh, okay. Well, then that's better odds. So
I'm sorry, Your Honor. Apparently, that doesn't happen to people. Mr. Moore, can you state your name? Can you hear us?
okay. I think so. Can you hear us, Mr. Moore? Yep. And tell us your name so we can hear you.
Tygar Moore.
Okay, very well. So we have the public defender here representing you. We've got the prosecutor. This is a pretrial. So counsel, I'll just ask what your thoughts are today.
Yeah, we had a resolution kind of pending in this matter, whereby the defendant is going to enter a plea to counts 1, 4, and 6. It's just like the other remaining counts 3 and 5. I think that he was looking to be sentenced under HIDA where appropriate. I don't know if count 5 needs to be HIDA or not. It might be specific. However, we just had a hard time. Mr. Moore has been bouncing around from Oakland County to MDC and back. We've had a hard time getting him, but when he has shown up, Oakland County has taken him out of the room or not logged in.
And there's some clear, hard feelings between Mr. Friedman and our public defender's office. I'm not sure where that arises, but, okay, well, are we ready to resolve it today, or do we want to make sure that we're good? I'm sitting here, Mr. Moore. You've got a host of lawyers in the room. So what do you want to do today?
Can I rewatch my videos? Because I kind of forgot.
Sure.
And I cannot.
So the only problem that we have, Mr. Moore, let me offer you this. So the case has been pending for some time, and it's been adjourned kind of since May was the first day, I think, and it's kind of been adjourned a lot. So I can give you one more short adjournment, and then we'll be going to either resolve the case or I'm going to set a trial. Or what I could do is set the trial today for probably February, and then you'll have an opportunity to review everything. And if you reach an agreement with your lawyers and the prosecutor.
So that means I can't review my videos, but I can have a trial.
So I am like, all right, so I'll start over. Okay?
Okay.
The case has been pending for a long time. It's been adjourned for months.
Because of what?
So I'm going to wait. You go ahead and tell me all your questions, and then I'll answer them.
So I've been incarcerated in Oakland County, and I want to say, like, a few months ago, y'all got a hold of him, and Mr. Freeman tried to get in contact with you guys, so that's why it's like a heavy burden on his shoulders. Just to clarify.
Really?
And then I was telling them from my videos how if I have, what is it called? Exculpatory evidence. If I got incarcerated overnight and I'm telling these folks that girls ran up on me in the bathroom and bouncers are harassing me.
Mr. Moore, don't speak about the facts of the case, okay?
You're on the record right now, and anything you say can be used by the prosecutor.
That's fine with me. I don't have nothing to hide. Literally.
Ah, screw you, that was funny.
I don't have nothing to hide. I could care less. But I literally get incarcerated by police officers. And then now that I have a problem with the police officers, indecent exposure with the police officers, now it's a problem. If y'all would have been called in the beginning, where is the evidence that proves my innocence? Where? My other lawyer from my other county is trying to get in contact with y'all, and that's not even his job. Make it make sense.
Seriously.
I'm struggling to make sense even of your questions, sir. So
I
here's
bet.
how
I bet.
here's how it goes is that you've been charged with 6 counts, different things. 3 of them are the
Right.
same, assaulting, resisting,
Right.
obstructing a police officer.
And then officers lie on me. I didn't even try to swing at this man or anything. They said I spit on him, and I flinched at.
Mr. Moore, the
Ma'am,
judge has given us an opportunity to adjourn your case for 1 week. And in that time, we'll get in contact with you and we'll rewatch the videos again and see if there's anything that we can do.
will we get in contact with me, or will it wait another couple months?
Or
Or until the last minute where I have to be pressed into making a decision or not? Because y'all had this whole time I've been incarcerated. I just moved to a new facility, and now y'all want to get in contact with me. Make it make sense.
Boy, you cute. He said it again.
Judge, it would be 2 weeks, right? The 29th, okay? So
Are
we're
y'all
gonna
sure?
do it for 2 weeks.
Or will my time get cut short again? Because I definitely have other stuff that on my
Mr. Moore,
schedule.
we're gonna adjourn your
Just like
case for
y'all.
2 weeks, okay?
Yep, I hear
We
you.
asked for an adjournment today, please.
So out of absolute respect for our public defender's office, I'm going to adjourn this for 2 weeks.
Thank you.
And we'll be back here. And if we resolve it, great. If we don't resolve it, then I'm going to give you a trial date. That's going to be February. There's still plenty of time.
Yes.
Thank you, Ron. Sure.
Thank you, Ania.
All right, and so we are on the record in the matter of the city of Wyandotte versus James Brunner, 231994. And Deputy Holman, if you can please unmute and turn on your camera. I think if you could just remove your hat since we're in court. And counsel, your appearance, please.
No, that's the record, John Wolf, Pete, 20658, on behalf of Mr. Bruner.
All right, thank you. And Mr. Bruner, your name, please.
James Bruner.
All right, and Deputy Holman, your name, please.
When I'm looking at your video right now, it shows that your microphone is off.
No, I know that my video shows that because our audio is through the courtroom. So if you're on your phone, you'll have to change your camera view. Can you hear me or no?
I can hear you now, yes.
Okay, yeah, that's because the it's on our audio. But can you maybe take me out of your ear, please?
Yes.
Okay. You readjust your camera, please. Okay, there we go. Okay. All right, and then can you just please remove your hat since you're in court? Okay, thank you. And you're not driving, right?
Repeat that again, please.
You're not driving, are you?
I'm not driving, my partner's driving.
Okay, perfect. Okay. All right, so I just want to make sure that you can hear everything. Can you turn the TV volume up, please? Or the Polycom volume up? Maybe that's...
Yes, I can hear you when I put it in my ear.
Okay. But maybe just put the audio to your ear and not the camera. Okay. Okay. All right. And so today's the date scheduled for a bond violation hearing, or a tether violation hearing. Mr. Brunner has indicated that he was pleading not guilty because he did not consume alcohol, and so we set this for a contested hearing. So, counsel, what's going on? Are we having the hearing? All right. All right, Deputy Brunner, or Deputy Holman, and Mr. Brunner, please raise your right hands. You solemnly swear for the testimony you're about to give this going to be the truth, the whole truth, and nothing but the truth.
Yes, ma'am. Yes, ma'am.
All right, thank you. Can you hear me better now, Deputy?
I'm sorry, repeat that?
Can you hear me better?
Yes, ma'am. Yeah.
Okay, all right, well, we turned the volume up on our device as well, so.
Thank
All right, and so Deputy Holman, I'm sorry, is there an individual that your client has here, so that person will have to be removed from the courtroom?
Yes, can you step out?
No, you have to step out of the courtroom, yeah. Yeah. All right, so Deputy Holman, Mr. Brunner was on the alcohol tether, and it's alleged on August 4th, October 18th of 2023 at 0700 hours, there's a confirmed alcohol reading.
Yes, ma'am. While I was conducting an investigation, or while I was conducting case management on the Scram network, I did see that there was an alcohol confirmed for the date of 10/14 at 5 p.m. at least until 8 p.m. I sent over the, what do you call it? I sent over the, I sent over a non-compliance for it, which states that shows a graph for the time of 5:05, and then it gets cut off down at the 8 o'clock mark, confirming alcohol all the way through.
All right, and what were those dates? October 15th?
October 14th, 2023 at 5:05 p.m. and then it continues to the bottom, October 14th, 2023 at 8 p.m. where it gets cut off.
All right, and how long have you been, you work for the Wayne County Sheriff?
The tether. Yes, ma'am.
In the tether unit?
Yes, ma'am.
And how long have you been assigned to that division?
About a year and a half, almost 2 years.
What does it indicate the levels were?
I don't have that directly with me right now, but it does spike up above 0.05.
Okay, and in your experience in the tether unit, would there be any other possible reason other than alcohol consumption that there would be positive testing or positive amounts with the amounts increasing prior to decreasing?
In my experience with the Wayne County Tether Unit, if there was any other kind of alcohol substance, such as perfume or something like that, the spike would go directly up and then directly back down. It would not be a gradual rise and a gradual fall. Gradual rise and gradual fall indicates slow progression of blood alcohol in the system.
And then you make contact with Mr. Brunner?
Yes, ma'am.
All right, and Mr. Goldpaw, do you have any questions for Deputy?
Deputy Holman, is it Deputy? I'm sorry, Deputy Holman. You indicated that it's your experience that there is when it's a gradual rise, that would normally, I'm using the word normally, only be because of use of alcohol. Is that correct?
Correct.
And you also said that when it was a gradual fall, that also is an indicator that it's alcohol. Is that correct?
The gradual fall indicates it metabolizing out of your system, so it'll read your blood alcohol content rising, and then as it's falling, it's showing your body metabolizing and getting rid of that blood alcohol content.
You do indicate that you do have the paperwork in front of you, or you don't?
I have the graph in front of me where it shows the time and the alcohol confirmed.
And would it be a fair statement that the graph shows that there was zero alcohol in the system up until approximately noon on that day?
Yes, it shows at 12/14/2023 at noon he was at 0.
And then there's another line right above it, says 0.025. What does that mean?
This line here that's at the 0.025, that's the indicator of it being attached, or the monitor on his leg. If there was something in between the device and the leg, this line would show very jagged. The bumps that you see, could just be an adjustment of the device that's attached to his leg. And then the line that's above that at the very top indicates his body temperature level.
Okay, thank you.
Yes, sir.
Now, so it's your, are you aware of any prior violations of the tether by Mr. Bruner?
Am I aware of any prior violations by Mr. Brunner?
Yes.
Not at this time. I'm not aware of any.
Okay. And I take it, and correct me if I'm wrong, part of your job is to monitor the tethers, and when you see this as a alleged violation, then you then go and make a report and then go pick the individual up. Is that correct?
Correct.
So on the day in question, which was the 14th, that's not when you went and got Mr. Holman, is that correct?
That is correct. I did not go pick him up on the day.
When you picked him up on the date, would it be a fair statement that he was quite surprised that he had allegedly violated this?
He appeared to be correct.
He was surprised, correct?
Correct.
Did you have any conversations with him about it, discussing why?
I did.
May not have?
I did. I sat in the back seat with him. I showed him the graph of it. I showed him the gradual rise and the gradual fall. I explained to him how we read this. And then we transported him to the jail. We had just a conversation, normal conversation on the way back, not dealing with the teller. I told him what was to be expected. I told him I was going to set him up for court the next day so he can talk to the judge. I said I was going to send a copy of the reports to the judge so that she could see it and review it. I explained to him typically my experience when coming across people who have violated. They typically get back out. They get reinstated. I told him that there's no guarantee and no promises to that. But just to calm his mind, I let him know that, in fact, most of the time, they do get back out on tether.
I understand. Thank you very much. And during this conversation, he denied using any type of alcohol. Is that correct?
He did.
I have another question, James.
Any reason why the deputy cannot be released from testifying? No? Okay, all right, thank you very much, deputy, for coming in to testify.
Yes, ma'am. Thank you.
You're excused, thank you.
All right, thank you. Good luck, James.
All right, and counsel, any witnesses? Okay. Hold on, Mr. Goldberg, joking about this. Can you just tell them your name, please? All right, and ma'am, your name for the record, please.
Rachel Avila.
Spell your first and last names again, please.
Raychelle. Last name A is Victor, ILA.
All right, please raise your right hand. Do you solemnly swear from the testimony about to give this family the truth, all the truth, nothing but the truth?
I do.
All right, thank you. And counsel, you may proceed.
Thank you. Ms. Villa, we discussed this matter in the past, is that correct?
Mr. Goldberg, I need you to keep your volume up,
Oh, I'm
please.
sorry. We discussed this matter in the past, is that correct?
Correct.
And you were present back on October 14th of 2023, is that right?
Correct.
Can you tell me what was going on at your residence or with you and Mr. Bruner between the hours of noon and 8 o'clock?
I just got back from a work trip, so we had some friends over to celebrate.
Okay. And by celebrating, does that mean you were having a party?
Yes.
And what time did that party start?
We started probably getting out around 11.
And what time did that party end?
It went pretty late into the night again.
Okay.
I'm sorry, it's 11 a.m. or p.m.?
AM.
And during that period of time, was Mr. Bruner with you the entire time?
Yes.
And during that period of time, was there alcohol served at the party?
Yes.
And during that party, did you serve alcohol to your friends?
I did.
Did you serve any alcohol to Mr. Bruner?
No.
At any point in time, did you observe Mr. Bruner drinking any alcohol or coming into any line of contact?
He did have something spilled on him, a cocktail. We were messing around in the kitchen and we got a little too rough and spilled it, but that's the only thing.
You're aware that Mr. Bruner is on a tether, is that correct?
Yes.
And you've had comments with him to make sure that he is complying with everything the court has ordered, is that correct?
Absolutely.
And in fact, it would be a fair statement that even during periods of time when he and you have been socializing throughout your relationship, since he's been on this tether, he has never consumed any alcohol.
That's correct.
At least to your knowledge, in your presence.
Yes.
And he was in your presence this entire time, and you did not observe any alcohol.
That's correct.
And ma'am, what did you observe Mr. Brunner drinking that night?
Sprite.
In the can?
Yep.
The entire time?
Yes.
You never had anything else in his hands?
I don't believe so. Maybe Dr. Pepper, but I know it was definitely Sprite.
And were you next to him the entire night?
Other than going to the bathroom, yes.
Mr. Brunner never got up and walked somewhere and you stayed sitting down?
Not that I recall, we were pretty all over each other.
For 12 straight hours?
Pretty much, yes. I don't recall anything.
And do you recall what time the alleged spilling occurred?
I honestly do not.
And how did that occur again?
Me and my friend were dancing and we were being rough in the kitchen playing, and she tipped over her drink, and then we cleaned it up.
And where'd she tip over her drink?
She was holding her hand, and we were like using brushes with our hands and stuff.
So where was Mr. Brunner when that
He
happened?
was standing next to us. We were trying to get him to dance with us.
Okay, and what was he wearing?
He had his house shorts on, and a t-shirt.
And was he standing next to you, next to your friend?
He was standing next to us, both of us, because we were just standing like he was in front of us.
He was in front of you?
Yeah, well, not like in front of us, because we were standing like this, and he was standing right.
So you and your friend were facing each other, and he was standing next to where the two of you were facing each other.
Correct.
Was he facing you or not facing
He was
you?
facing us.
Was he to your right or to your left?
I believe he was, I don't recall, honestly, I don't recall.
And Mr. Brunner, what leg was your tether on?
On the left, seems it is now.
And so your friend spilled the drink on Mr. Brunner. Because I know that he wasn't really testifying, I just had a quick question. And your testimony is just happened to go down his left leg and not any other part.
I don't know exactly where it all spilled. I know we did spill it on him.
Okay. And any further questions based upon those questions, counsel?
None of this was shown.
Any further witnesses, counsel?
No, you want to just.
Okay, all right, thank you, ma'am. You may have a seat, thank you.
Mr. Brunner? Yes. You've been on an alcohol tether since
Correct, everything's muffled because someone's not continuing to keep their voice up.
Brunner, you've been on an alcohol tether since about October 4th, is that correct?
Earlier than that, I was put on the line.
Okay. But there comes a point in time when you're on this alcohol tether and you know all the rules and regulations are.
Absolutely.
Okay. And one of those rules and regulations is not to drink alcohol. Is that correct?
That's the biggest one.
It's the biggest one. And throughout that time, you never had any violations of your alcohol test.
No, sir, it's not worth it.
And you've been on probation, or you were on bond for a lengthy period of time.
Correct.
And prior to you entering into your sentencing, you never had any violations of bond violations or any other thing dealing with alcohol. Is that correct?
That is correct, sir.
And you were scheduled for sentencing in this particular matter a couple of weeks ago, right?
On the 25th.
And from the point in time that you entered into your plea until the date of sentencing, other than this alleged violation, you were not violated in any way, shape, or form for your bond or probation. Is that correct?
Yes, sir.
On October 14th, we've heard testimony that there was a party going on at your house.
Correct.
Where other individuals drinking alcohol.
Yes, my girlfriend and my friend Rachel, or Lindsay, sorry.
Okay. And was there anybody else at this party?
My 2 kids and Lindsay's 3 kids.
All right. And at any point in time during that party, did you consume any type of alcohol?
No, sir, no.
You indicated that, and Ms. Avila indicated that at some point in time, there was a spillage of alcohol and it came on you. Is that correct?
Correct.
And do you recall approximately when that occurred?
No, sir, sometime while we were making dinner for the kids, we were all making our own pizzas, we had the music on, like she said, and she was trying to give me the hands, we had a very small kitchen, and all accidents happen, and accidents.
No other questions, this one.
So it was just the 3 adults and the 5 kids?
Yes, ma'am?
And you didn't leave the home at any time?
No, ma'am. I'm pretty much a her and don't.
I recall the last time you were here on October 31st, when we set this for today's date, that you indicated you left and went to the store to go buy alcohol.
Oh, correct, yeah, that was just, yeah, I went and bought cigarettes and I made sure that they had beer and stuff for the party, absolutely correct.
So you weren't
Well, that
right
was
next to Miss Avila the entire time?
I mean, for like a minute or 2, yeah, I just went to write it.
What time did you go to the store?
I'm not sure.
Was it before or after 12 o'clock?
Probably before? Yeah, cause they came over and made sure they had everything they needed, so we didn't have to leave us. We made our own sourdough, we rolled out our own dough, let everybody make their own pizza, so, like, when it did get spilled out, we didn't think anything of it, we just let the kids do their stuff, and that's probably why there was a rapid decline, because the minute everybody sat down, I got in show.
Rapid decline didn't occur until 8 o'clock, after 8 o'clock, sir.
Yeah, we made lots of pizza, every kid made their own individual pizza and everything, we were at it for hours.
Okay, but there is a gradual incline to the peak amount of just over 0.05.
Right.
And then it was going down. So you didn't notice it had been spilled on you for a couple of hours?
I didn't wash it off, I just wiped it off with a towel, I didn't think anything of it, to be honest with you.
Well, unless the entire drink was poured right on the
It
tether.
literally was,
Okay.
right down in front of you.
In front of you.
Yeah, right down, like all over, feet and everything. I changed my socks.
So you changed your socks, but then your testimony is that you didn't clean up.
Did I mention you're a moron?
Not like in the shower, no. I just wiped it off with the dish towel. Like I said, we were all with the kids, doing stuff to town, making their pizzas, you know, like, I didn't see like it was a huge deal. I didn't know that could happen. So I, like, when that's why I was really surprised when he showed up.
Okay. Any questions based upon that, counsel?
No, Your Honor.
All right. Anything else, counsel?
No, Your Honor. Only that I've indicated that, as you're well aware, talked about this, the court said she would bring this up at our next hearing. Mr. Bruner is on probation to this court. He has taken great steps to get his probation taken care of in a timely fashion. He has already attended a number of work, done 3 of his work matters. He's also paid all my fines. He's paid all his costs and fines in this particular matter, even though he is eligible for early release in this particular matter. Your Honor, it seems hard to believe that Mr. Bruner and the man that I know would have intentionally done something to violate the court's orders. He has been added throughout these proceedings. He has taken all the steps to rectify his bad judgment, for lack of a better term, at the time of this incident. And I'm sure, Your Honor, that when he tells you that he did not consume any alcohol on that day, contrary to the tether or this court's orders, that he is telling the truth. It's not like he was sitting drinking and partying with his friends, even when you look at the it would be interesting, to say the least, that he's at a party with a number of people who are drinking, and he just decides, well, if I'm one drink and stop. This clearly is inconsistent with both his way he has handled this matter, as well as, Your Honor, the testimony that was presented to me.
Okay.
So I've done 2 of my substance abuse counseling classes. I have another one today, and my intake for Sandcastles is tomorrow morning at 10:30.
Okay, very good. All right, the court has heard testimony from Deputy Woolman, from Ms. Avila, and from Mr. Brunner. And Ms. Avila testified that Mr. Brunner was by her side the entire time. They were pretty much all over each other for 12 hours, which based upon Mr. Brunner's testimony that he had left for a little bit to go to the store, and then they were rolling pizza dough all day long. I'm not sure how that's all happening when people are on top of each other, but in any event, the court doesn't find that Ms. Avila's testimony is completely credible. The court also, based upon the testimony of the deputy regarding on the data, on the graph, the gradual increase and then the decrease, that's not consistent with anything other than consumption. And even Mr. Brunner and Ms. Avila's testimony that something was spilled on Mr. Brunner, the court doesn't find that credible as the reason that this increase occurred. There may have been something spilled on Mr. Brunner, but I also don't believe that with the gradual increase over, it appears to be 2 hours time, almost 3 hours time, that is consistent with the spill. Based upon this court's experience and the testimony the court heard, the court's going to find Mr. Brunner guilty for the tether violation. The court will order 3 additional days on the tether as sentence. Set seat over probation. Somebody will be with you shortly.
Thank you, Your Honor.
All right, so Mr. Serrano, we're going to go on the record in the matter of the City of Riverview versus Lisa Madal, 232169. All right, counsel, good morning.
Your Honor, good morning. Richard T. Serrano, P33828 today. Your Honor, I appear on behalf of my client appears to my right. And this today is a arraignment pretrial. Please take your name, ma'am. Come up here, take your hand out of your pocket, please.
Lisa Madal.
All right, thank you. And today is the date for the arraignment pretrial in this matter. And counsel?
Your Honor, I've explained to the client the nature of the charges. She understands them. Everybody will wait for the reading, stand mute.
The court read the formal reading, enter plea of not guilty for purposes of the arraignment. And as to the pretrial?
Your Honor, after meeting with the prosecutor, my client is going to avail herself of the offer in that she will plead responsible to the amended charge of loitering in a public place, civil infraction. She understands what that entails. She understands she will not have the benefit of a trial and or a hearing. She can wait freely and voluntarily. And we're ready for the court's examination.
Please raise your right hand.
I do.
Okay, ma'am, are you currently under the influence of anything?
No.
Are you sure?
Yes.
When's the last time you consumed any alcohol or drugs? You can put your hand down.
Oh, it's been a couple months.
A couple months?
Yeah, I get treatment from the Park Community Care Services.
And so what does that treatment entail?
Bipolar and general anxiety. I'm on medication, so I can't drink on anything.
You don't drink?
I don't drink on medication, no.
Okay, you don't drink at all?
I used to, I don't anymore.
How long has it been since you had any alcohol, ma'am?
I had some wine about 3 months ago.
3 months ago?
Yeah.
Yes?
Yes.
Your Honor, she has someone with her today that has all her prescribed medications, a list of that, if the court wants to see that.
I also have a doctor's note.
Okay, I'm watching your client's behavior, so that's why I just wanted to confirm that. Especially in reviewing her criminal history and how many disturbing pieces and disorderly conduct she's had dismissed, and the prosecutor dismissed this one as well. It appears as though you have an issue with alcohol consumption.
Yeah, I don't drink anymore.
Well, Your Honor, he's not entirely dismissing it. We are admitting responsibility to the civil fraction, but he's dismissing the criminal matter if the court adopts the plea.
Right. No, I didn't know that part, but. All right, and ma'am, you heard the plea that was placed on, I just want to, yes, you heard the plea that was placed on the record, correct?
Correct.
And as to the amended charge, ordering in a public place, how do you plead?
Responsible.
You found out your advice of rights, correct?
Yes.
And you understand all of those rights?
Yes.
You also understand by entering into plea that you'll be waiving some of those rights, specifically your trial and appellate rights?
Yes.
And you also understand the possible penalty as a result of your plea, correct?
Yes.
And knowing all that, you still want to continue with your plea?
Yes.
Any immigration issues?
No, Your Honor.
All right, has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
All right, the court will accept the plea as knowing and voluntary. And ma'am, let me just make this very clear. If you have another disorderly conduct or disturbing the peace or something along those lines like this type of plea will likely not be found to be in the interest of justice. Do you have that to pay today?
How much is the fine?
$150.
Yeah, we can pay today.
You paid entirely today, ma'am?
Yes.
All right, have a seat in the lobby downstairs or outside, and somebody will be with you shortly.
Thank you.
Have a good day. On the record, we're recalling the matter of the state of Michigan versus the city of Ania, 231375. Good afternoon, and counsel your appearance, please.
Your Honor, John Hill, 4P 30758 on behalf of Ms.
Ania.
All right, and so today's the date scheduled for sentencing in this matter on your client's plea to an amended charge of disorderly conduct from assault and battery, and it's not lost on this court that your client has a sentencing for assault and battery tomorrow also.
Correct, Your Honor.
And it's my understanding that Ms. Bergeron, or Jade Bergeron, is present and has been present, I'm sorry, Mr. Bergeron, and has been present all morning, so I apologize for that. And counsel, did you have an opportunity to review the report and recommendation with your client?
Yes, I did, Your Honor. In fact, I sent it to her. She had an opportunity to review it before today. Fortunately, I didn't know she was here. I do apologize for that. She has been waiting.
I'm sorry, she was?
She has been waiting patiently for me to come here, and I didn't know she was here, so I do apologize. Your Honor, I have had an opportunity to review the report. There are no additions, deletions, or corrections to be made. She did want me to bring to your attention, this will come with the any costs and fines that are rendered against her, that she was just a victim of retail fraud. So she has no availability of funds.
What does that mean? She was the victim of retail fraud? She
No,
doesn't own the
I'm sorry.
No, my debit card. Yeah, my debit card, it was on fraud watch, so I have to get a new debit card. This happened last week, so I'm waiting for my new card to come in, so I can't transfer money or do anything with my old account.
That's what I meant.
You can't go into the bank and withdraw money?
No, it's unlocked.
So I just want to bring that to the court's attention, because she does understand those circumstances. Other than that, Your Honor, this was discussed with her. There were no additions, there are no deletions, corrections, or additions being made. Is that correct? We have reviewed the recommendation. I see that this is recommended under 771.1. I appreciate that. And Ms. Scholl, I also am aware of the other matter, which is subsequent pending. We have discussed that. It's my understanding she will be here for sentencing tomorrow, and that's she's also other than that, Your Honor, I don't believe she has anything else to say. I've also explained to her what early termination means, and she's quite remorseful, Your Honor, for these circumstances. It was something that clearly got out of hand, and because of that, the circumstances that just become quite a burden on her, as well as on, I'm sure, the victim in this particular.
You're trailing off. You said the victim what?
As well as the victim. I understand, you know, and what she has gone through. She understands. Is that correct?
Yes.
Okay, Jade, if you, and I believe your father's present, like to come forward.
It's not.
Oh.
She doesn't.
Oh, okay.
I remember this. Mine.
Well, okay, and sir, your name for the record, please?
John Bergeron, I'm her father.
Yes. We can go over to the podium, sir. Well, both you and your client can go that way. All right, you can spell your first and last name, please.
J-O-H-N. Bergeron.
Okay. And you are Jade's father?
Correct.
All right. And what would you like the court to know, sir?
Well, one, I know he said that he understands what Jade went through, he doesn't. That's for sure. Daughter's never been in trouble at all, never been in a fight, altercation or anything. She got sacrificed. Pretty scary for her, and she's still feeling some things, right? She would have loved to have been here, but we thought school was a little bit more important for her. That's why she got, so I apologize, Ron. Couple things. One, I think what happened in Jade speaks for itself, and then I am aware that there's a second incident that happened as well. So I think that kind of speaks, actions speak louder than words. I think the court needs to take that into consideration, that's for sure. So if he does something, I think they should be held responsible. That's how I raised all 5 of my children, my wife and I, and I'd like to see that here as well. There also is a matter of restitution as well. My wife called in the last week and asked her insurance company, because we had to go to the ER for Jade. As of right now, it's not showing anything, but bills do trickle in down the road, so I'm not sure what the court can do on should we face anything there. We'd like to make sure that, we can pass those any bills on. As of right now, we don't know anything, but the insurance company said, hey, the doctor or the hospital could bill us down the road. The last thing I would say is I hope there's a restraining order. I think there is on her. I'd like to keep that for whatever time as a probation or whatever she gets.
And she went to the hospital to be checked out, and was she diagnosed? Did she have any, what was the result of her hospital visit?
So the reason why we took her is her nose was swollen and she was bleeding pretty good. So we went in there and the ER doctor said that, look, we could, to his best of his ability, right? He's not a otolaryngologist, right? He's not an ENT doctor. He didn't think anything was wrong, but to really be sure, we could take those next steps. I consulted, I actually sell medical equipment and been doing it for 30 years, so I know some ENT doctors. They said that from what I described and showed them that most likely not, but they'd be willing to do anything. So we didn't take those next steps. The swelling eventually went down, and but that's what we're trying.
All right, thank you very much for coming in. Okay, and Mr. Gopal?
Stand in that statement. With respect to the restitution, investigation, restitution is sought is 0. The court, of course, can always, if something comes up, determination with proper documentation to support a request of restitution. It appears at this point in time that they have not received any bills for the hospital emergency room. This incident occurred over 3 months ago, which in my billing stages, when I get billed, hospital released my insurance company. I just bring that to the court's attention. So maybe something will come out as he's indicated. Maybe something will not. At this point in time, nothing has been shown to support any restitution at this time. Other than that, Your Honor, as I've indicated, as Ms. indicated, she understands this role. She's taking steps. She is accepting responsibility. She wasn't accepting responsibility, Your Honor, it wouldn't be before this court at this point in time. She accepted responsibility when she entered into the plea that was offered. So that is what's coming at this point in time. We asked the recommendation be adopted that this particular 7711 because she is open. And also because, Your Honor, we also asked that under early termination of conviction. We were aware at the time that this plea was entered, it was never matter pending.
And we were also aware at that time, that it was a matter pending, not hadn't been called. So I want to bring to your attention that we did discuss this, and she's willing to accept responsibility for all of her actions. And that's all I have to say at this point.
Ma'am, who are you here with today?
My mom.
That's your mom right there in the dark hair?
Yeah.
Yes?
Yes, that's
Okay. If I recall correctly, I think she's been before the court for some attendance issues,
not with me.
right?
Yes,
Right, because you just graduated.
She's graduating,
Yes.
around, she's
Yes.
on her way to college, she's working.
Yeah, and where do you go to school? And ma'am, so you just pulled up to this house or to the street and encountered Jade?
No.
No.
She was leaving when I arrived, and like I said in my report when I talked to the detective, she was in a white Fusion with someone else. They rolled down the window and I couldn't see who it was because I've never actually seen her in person. And they screamed something, then drove off, left the party. So
Who was the other person?
I believe it was her friend, Samantha Pico.
Oh, okay.
And we went to a party, like me and my group of friends, and she came back. And the party goers made it like a big deal that she came back, like the party hosts. Like they were trying to keep, like, it wasn't that they were instigating, but they were trying to make it seem like something that it wasn't. And I had heard like arguing and stuff up front, like they were trying to get them to stay up front, us to stay in the back. And I just wanted to leave. Like I just wanted to leave because I didn't want anything to escalate.
So was there some beef between you and Jade for some reason?
Well, I didn't know why she screamed. Like they screamed something and they drove off. And that's what I said. I didn't know what was screamed. Like I've never met her before. I mean, she had some relation with my boyfriend before, like 2 years before.
There we go.
Started
There's a
dating.
boy in common. What relation was that?
They talked. When it's they dated, they talked. You
I know, because there's that stupid thing that they're talking. Not dating, but you're talking.
Like I was saying though, I never met her. She goes to Flat Rock. I went to Wyandotte. Like I never had any actual contact with her.
And so from 2 years ago, there was some unknown beef because the two of you had some guy in common.
Well, that was the only common ground. There was nothing else. Like I didn't even know why she was at the party. It was a Wyandotte party. I mean, there's people from everywhere, but I didn't know.
That would be called social media. People just put it out there and people show up. Go ahead.
But yeah, I was walking out. She was being held by, I mentioned in the report, by another kid. Like he was like standing in front of her kind of, and there was just arguing back and forth. I was trying to get through the gate. I was shoved. Don't know who I was shoved by. To this day, I still do not know if it was her, who it was. And then that's when the punch occurred. That was it.
So you were shoved and then you punched.
Well, it came from that side. I was walking out of a gate like this. It was everyone was trying to get out. People were trying to get in. It was just a big deal. Like it was just circles.
Which is why there shouldn't be underage parties. How about that?
And the cops had been like, I know that it was a problem. That's why they were trying to like shut it down, get people to go home, and that's why I was just like, because when that started to escalate, we kind of like knew. And at the time, me and my friends had all just turned 18, so we can actually get in trouble for even just being there.
So how is it that you ended up punching Jade specifically?
I believe, Your Honor, and she.
Well, but I'd like to hear from her, please.
It was just like the other kid, the kid that was with her, he moved out of the way. Like I just like went like this. It wasn't like I know that I hit her, because I didn't continue to hit her. Like it wasn't like I was going to fight her. It was one hit and it was done. I know I hit her. I take responsibility for that. But when I turned around after getting shoved, they were all laughing. So I'm going to assume they had already screamed at me. And like the kid that was standing like this with her, like he was just like looking like that. Until this day, no one has came forward and said who pushed, who shoved. Everyone just kind of like stayed out of it because they don't want to be involved in this, which I understand. and it's my responsibility, so I wouldn't want to get them involved. That's why I pled guilty and I didn't ask for a trial or get anything else involved.
And was the person that you assaulted, that you're being sentenced for tomorrow, was that person also at the party?
Yes, she was there. She was there, and it happened the day after. Everything happened right after, so it was kind of like, oh, she's seen that kind of. That's what I'm taking it as, because she was there. The girl was there. She had seen what happened. She didn't say anything to me at that time until the day after. Then she kind of had some stuff to say about it, and then it resulted in that.
And so then you responded by punching her?
No, that was like a totally different incident, which I'm sure we'll go.
I mean, okay, you got pushed, so walk away. Who cares? You're at a party where everybody's trying to go in and out of a gate, and you got pushed. Who cares? Who cares? Just when you're walking at a concert and everyone's trying, you have 15 different paths down the concourse. Some are going one way, some are going another way. Nobody can go in the same direction. On one side and the other side. You have everybody's. It's like a zipper, right? People are pushing people. If you're in a concert, you're going to turn around and punch somebody in the face because they pushed you?
It was just I had.
Is that what you're going to do?
No.
Okay, no, you had beef. You had beef with Jade because she talked to the guy that you were dating a couple years ago. Who cares? Who cares? They were younger, right? 15 years old, 16 years old. Who cares?
Your Honor, I believe because she is dating the gentleman.
Ania is dating the gentleman. I understand that. But because Jade was talking to her boyfriend 2 years ago, there's some unspoken about beef that they just don't like each other, right? And then and then Jade and the other girl or the other person in the car, somebody yelled something. Okay, so then there is already that tension.
And then they came back and it just made everything.
Okay.
And
well, the fact that people were making a big deal about it tells me that there was something more than just the fact that they knew she used to date him and now you're currently dating him. I mean,
that's what I don't get though, is me and him have been together for 2 years, so I feel like something would have came up by now. Like, we've been together for 2 years and I've never heard anything from her or anything until this one time I see her in person. And it's like,
I cannot explain, even though I have a 16-year-old daughter, I cannot explain how the lack of, I don't know, I can't even think of the word right now, how the adolescent mind works now that social media has made it so much worse. But I also know that typically, if there's some continuing comments or something, I don't know, that's what usually keeps it going. Jade isn't here, so I can get that side of the story because I think that would also be interesting as well. What the court's going to do after hearing from Mr. Bergeron, hearing from Ms. Ania, hearing from counsel, reviewing the report, the recommendation, the court does find there's reasonable grounds to Department MCL 769.5. The court's going to order 12 months probation. You are eligible for early discharge, and I'll go over that shortly. You're also eligible under 771.1. But ma'am, keep in mind that one violation, that's revoked. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You're to notify your probation officer immediately of any change in address or employment status. You're not to any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitatable for that condition is to make sure you're maintaining absence and sobriety, especially because you're not 21 yet. The court's going to order you to not have any contact with Ms. Bergeron. That's phone contact, text message, email, social media, third party, anything of the like. Nothing. You're not to return to Roosevelt High School. I don't know if your boyfriend's still in high school or not. I don't know. Is he?
yes.
Oh, so they attend the same high school?
No.
Oh, no, she goes to Flat Rock. That's right.
She went to Roosevelt.
Okay. All right, so you're not allowed to go to Ms. Bergeron's home, her school, or her place of employment. You are to participate in 12-week anger management class. The rehabilitative goal for that condition is hopefully assist you in learning how to express your feelings and needs in an appropriate fashion, and to emotionally prepare you for upsetting situations such as this one. The courts would order $0 in restitution at this point. If there are additional bills that come through, then Jade will have to notify probation, and then we can set up for a restitution hearing. And the court's going to order mandatory revocation of 771.1 status for any violation. Any questions?
No, Your Honor.
Bergeron, did you have any questions?
I do have, if I could step up and ask, please. So, the one thing that we actually turned over to the detective at the time was she actually did a text to my daughter before the party where she arrived and told that she was gonna kick my daughter's behind in a 3-letter order. So that text was pre anything she showed up.
And it was from Miss Ania?
Yes.
And how do you know it was from Lucinda Ania?
It has her name on the text on it, right? It's from, my daughter turned it over to the detective at the time and everything, so that's all part of the record. So this time, she didn't know her or anything, no, she deliberately came to that party with the conditions that she was gonna kick my daughter's.
Did you send her a text or a Snapchat? It's probably a Snapchat.
Probably Snapchat, I don't have any of that, so I apologize, but it was all.
Which it looks though as though it's a text, but it's the words through Snapchat, yes.
Just, you know, I mean, that was premeditated.
Okay, all right, thank you.
Thank you.
May I address that?
Okay.
We reviewed all of the discovery before this. Before we look at the police reports, there is no mention of her texting or having any contact with this young lady. She denies ever texting her. Is that correct?
Yeah, they didn't say I texted her or anything. They said that I did, but they were like, do you have text messages? And I said, no.
Do you have Snapchats?
No, I didn't even have her on Snapchat. Because when I got questioned by the detectives, they brought it up and they asked. And I said, no, I don't have anything. Because after it happened, I knew what was going to happen, so I blocked her on everything so that nothing could be started, like from social media, so she couldn't text me.
Well, hold on. I may be older than you, but I know how that kind of works.
No,
for the most part. Hold on. If you have somebody added on Snapchat, then you can block them. But there's not a way to block them before you add them.
No, I'm talking about like on Instagram. So on Instagram, like I can block them so that she can't even message me because it would pop up in like a thing called requests. Because I knew that it was.
So then your Instagram account's not private?
No, my Instagram account is not private.
Okay, so is she following you on Instagram?
No, not anymore.
Was she, I said?
I don't believe so. I just didn't want any drama started because it was already getting said that she was gonna go to the police. So I already knew that it was coming, so I didn't want like her to say like I just didn't want anything. It was already so much was going on at once. Because she's everything. But there's no text messages.
Well, I was going to indicate this, okay? In the police report, page 4 or 5, Lucinda withheld her information regarding the Snapchat exchanges, but when confronted, admitted that she and Jane had exchanged Snapchats with one another prior to the incident. That was from the officer.
It wasn't prior to the incident. It was not prior. It was after she screamed at me. I thought that you were saying that prior to me hitting her, like I had said that.
Right.
No, I did. I just asked what she screamed at me. That's why I kept
You just told me that you didn't send her any Snapchats. I said, did you snap her at all? Did you send her any Snapchats? You said no.
I didn't snap her. I didn't snap her. Like
you told the officer that the two of you had Snapchat exchanges.
No, I just asked her what she screamed at me. So yeah, like a text.
On Snapchat?
Yes.
That was what I said. I'm very familiar that a snap is a picture. Snapchat is a text message on the Snapchat app.
Okay.
So I may be older than you by a lot, but I'm very familiar and aware of what that is.
That's on my part. That's on my part.
So when I said, did you send her any Snapchats? I didn't say you send her any snaps, right?
I didn't.
Snaps are pictures. Snapchats are text messages via Snapchat. So I said, did you send her any Snapchats? And you said no. And then you said I blocked her from everything. And then I said, you can't block her from something if she is not already following you on Snapchat. So you guys must have been friends on Snapchat, right?
Yeah.
Right. So do not come in here telling me that it just out of the blue occurred. Because I'm smart enough to know that. And to read between the lines. But don't come in here tomorrow trying to tell me the same thing. Because I'm smarter than you think I am. So let me be very, very, very clear. There is not to be any contact with Ms. Bergeron on any social media format. You are not to direct anybody else to have contact with her on social media or otherwise. As the fines and costs, the court's going to order a $500 fine, $100 screening assessment fee, $600 supervision oversight fee. That's $50 a month at 12 months. Since you're eligible for early discharge, some of that money may not be due. $200 for the cost of prosecution. Crime victim assessment fee of $75. Justice system assessment fee of $50. As of right now, there's $0 in restitution. Total $1,525.
I'm sorry,
$1,525.
thank you.
How much can you pay per month and what day of the month works best?
So like a date, like, can I do the 20th?
Of every month?
How much can you pay each month?
Can I do 100?
Yes. Beginning November 20th? All right, $100 per month beginning November 20th. And you are 18 years old, and you indicated you're doing your prereqs. What program are you studying?
Ultrasound.
I certainly hope this 12-week anger management class helps you in learning how to process emotions in emotionally frustrating situations, because you will find yourself in some of those during your professional career as well. And you cannot respond by hitting somebody. I'm sure you have a lot of anger. I recall your mom when she was addressing your sister's issues. And so there's probably a lot of anger. So in addition to the 12-week anger management course, you might want to look into some counseling and some therapy. Well, you might want to go back to it, because if you received any coping mechanisms, you apparently forgot how to use them. Did you think you can?
Well, I was just confused on what you meant by anger, like with my mom, sister, or like about that.
You seem to be angry.
I don't get angry. I keep trying to tell you and that judge that I do not get angry. If somebody do something to me, I do something to them. That's just common sense.
So you believe in getting even?
Hell to the yeah.
Okay. Look.
Are you getting angry, doctor?
You have 2 cases for assault and battery with 2 different victims a day apart. You have some anger somewhere within you. That is what I'm referring to. All right, have a seat over on probation. Somebody will be with you shortly. So on the record, in the matter of Lucinda Ania, 2-3-1952.
Good morning, Richard T. Serrano, 838 Wade, sharing on behalf of my client. Today's next step for her sentencing, Your Honor. Please state your name again.
Lucinda Ania.
All right, good morning, and good morning again, and thank you again for addressing appropriately for court. And counsel, just so you're aware, Ms. Ania was here yesterday at sentencing on another matter. It was assault battery amended to disorderly conduct with a victim of Jade, and this is a victim of Jordan. Is Jordan present? No. Okay. And so I don't believe that there was much of a change in the report, the PSI and recommendation, other than in this matter there was not a request for restitution.
That's correct, Your Honor. I've had an opportunity to speak to Mr. John Goldfault, who was their attorney on that matter yesterday. He kind of brought me up to speed what happened. My client and I also talked about it. Your Honor, yes, we would hope that the court would adopt the recommendations contained in this case. Obviously, my client knows she has to do much, much, much better. The household she lives in, my client also has a sister, Isabella, which the court heard from earlier when her mother's case was called. There are 3 ladies in that household, Your Honor, and they're all going to try to work together to help each other abide by the court's orders and get to school and be responsible citizens. Your Honor, I have nothing really to add to the report, other than, we hope the court would adopt it, take it pursuant to the HIDA plea that we pledged to, and let her do her time on probation. Is that correct, ma'am?
Yes.
She's presently in college now, Your Honor, and she has no reason to have contact with the victim, Ms. Jordan. Also, should be noticed that she's still in the guidance center. Is that correct? Are you still doing the guidance center treatment or not?
No.
Okay.
Okay, so tell me what happened with this altercation.
So me and my friends went to go see one of our friends that happened to be a Jordan. His name's also Jordan, so that gets confused. And he happened to be with this Jordan. Me and her have never had issues before. She was friends with, we were equals. So we talked, but it wasn't, we didn't have like, we weren't best friends. And there were stuff said like from her about me, just high school stuff. And that was dealt with in high school. I never had a problem with her in high school, none of that. She was present for the incident that happened the night before, so she had seen that. She didn't say anything that night. It didn't seem like it bothered her that much. The victims are friends. So in this case, we went to go see our other friend, and they were parked outside of a house that it wasn't any of their houses. It was like they were in a group, I was in a group. We went up to their car, and she was already getting out. Like she was already, I think she had to go use the restroom or something. And she was already getting out, and she just had an attitude already. And they were telling her like, oh, just go to the bathroom, like we'll be back. The friends were saying like, oh, we'll be here when you come back. And she just had like an attitude. And then she started bringing up the incident from the night before, and it was just arguing, like not arguing, but I just asked like what the issue was, because she wasn't involved in the other incident, so I didn't understand what the issue was. And that's when she started to get angry, and she like had a belt bag on. She threw her belt bag off and stepped out of her car. And like I was standing at the back window, and she came up to me, and I was like, what's the issue? At that point in time, I understand now from what you said, I should have just walked away and just waited for the friends to come back to the car. And that's when I went like this, and I was like, get away from me, because I didn't want what happened yesterday to happen. And then that's when the fight started. In this case, I did not hit first. And I made that very clear. Because I know in the report she said I like dragged her out of her car, or I hit her while she was in her car, but that's not what happened. And I told the detectives that. They said that they were going to see if there was ring camera footage. I don't know if there ever was. But ever since then, I haven't had any contact with her. She still posts and says stuff all the time. I don't respond to it because I'm the one with the no contact. Like the last time I had.
Oh, go ahead.
Oh, sorry.
No, go ahead.
The last time that I had my arraignment for trial, they watched the live stream and they posted about it, and obviously got back to me, but I didn't respond to it. I've talked, like when I came to make a report, I basically was told that like there's nothing that I can do about it because I'm the one with the no contact, but I haven't responded to anything at all.
Okay. So what are some posts that she makes that you're talking about?
She doesn't say my name, but in one of the posts, I have all the screenshots. She posted the last time I had court, watching her court day live was the entertainment for my day, or something like that, something along the lines of that. And then after the incident had happened and I had talked to the detectives, they had told me like if she posts anything about the fight or anything, let us know. She posted a day after, basically saying like, I've been waiting to beat this girl's ASS, have fun in jail. And when I called the detective to let him know, I never got a call back or anything, but I have all the screenshots and everything. Okay. But I haven't responded to anything at all.
I think that's the important part, Your Honor, that she's made no further attempts to contact her or make any comments toward what the victim in this case has posted. My client's right, she has no contact order and she's been abiding by it.
So this one didn't involve anything regarding the boyfriend this time?
No, it says that, but that's also what the other girl said. And like I said, they're friends, and I was questioned about this case. I was questioning about both of them at the same time, and nothing about the boyfriend got brought up until they read the report, or I was read the report, and that's what she said, but they didn't bring it up to me at the time.
Okay.
So.
All right. Okay, and so counsel, anything else?
Nothing further, Your Honor.
All right. And so the court will state the following. After hearing from Ms. Ania, hearing from counsel reviewing the report recommendation, the court does find that there's reasonable grounds to park on MCL 769.5. The court also is familiar with the situation from the sentencing yesterday as well. So the court will note 12 months probation. You are eligible for early discharge with the hearing. This matter will be taken under the Home Youthful Training Act. You're not to violate any criminal law or any of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You're to notify your probation officer immediately of any change in address or employment status. You're not to need alcohol or drugs unless prescribed to be subjected to random testing. Rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. 12-week anger management program. It's not an additional 12-week anger management program. It's the same 12.
Yeah.
I say 12 months, 12 weeks.
She explained it.
Yes, okay. And so the rehabilitative goals for that, which I know I went over it yesterday, but for the record, is to assist you in learning how to express your feelings and needs in an appropriate fashion. Revocation of HIDA for any probation violation. Restitution is 0 because there hasn't been any requested, and no contact with the complaining witness. The rehabilitative goal for that condition is to ensure the safety of the victim and hopefully prevent this matter from happening again. Okay. Any questions regarding the terms and conditions?
Just everything is running concurrently for the same period of time, Your Honor, and complications.
Yes, I will note that as well.
Thank you.
As the fines and costs. $300 fine, $100 screening assessment fee. The supervision, this is a separate case, so there's still supervision and oversight costs. I'm going to cut those in half, given the other case as well. So it would be $600, which is 12 months at $50 a month. I'm going to indicate $300.
Will she be seeing one probation officer?
I believe so.
Yes.
Like that would make the most sense. Yes. $200, and so because you're eligible for early discharge, you may not owe that entire amount. Okay. $200 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, $1,025. And so, what type of payment plan? That I don't recall everything.
I'm for the case from yesterday, I'm paying every 20th of the month, 100. So, for this one, can I do like a different date instead of like the 20th?
Yes.
Can I do the 8th of each month, and can I do 50?
Yes. All right. And you recall everything regarding the early discharge, correct?
Yes.
Okay. So, do you need the court to go over that again? Okay. Then I will not. Okay. Please have a date open probation, and somebody will be shortly.
Are you kidding me? Oh my God. You have got to be kidding me. What is going on today? This is a joke. This is a joke. Jade is not a joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Ms. Green, we're gonna start bringing people in court. People gonna learn how to act in the courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am, can you hear it?
No, I know.
Okay.
I have no patience for that. Trust me, out of the day, I'm sitting up here, I'm the one that's